as the anti-SLAPP coalition says, without a dedicated anti-SLAPP law, everyone in the UK remains at risk if they choose to speak out on matters of public interest, and this undermines the democratic health of our society. The case I want to talk about today is that of Ben Jenkins, a citizen who made critical posts and comments in various forums about the housing provider with whom he co-owns his home as a shared owner, GreenSquareAccord. In my work as an elected representative, as a local councillor, as a London Assembly member, and now as an MP, I have often met and worked with and supported people like Ben. Campaigners who speak up when their housing provider fails, when their complaints disappear into the system, when their attempts to work with and multiply and show the patterns in the impacts that are happening to their fellow residents are delegitimised. We have all seen how these kinds of dynamics worked around the disaster at Grenfell and the way the residents there were treated before the fire happened, about the ongoing issues within that building. These are all too common, and it is exactly the kinds of concerns that local grassroots campaigners bring out that the big, powerful companies and organisations that run these homes most want to suppress. You can see why the dynamic of SLAPPs comes into play in these cases. Now, Ben Jenkins has faced a series of serious legal threats from his social housing provider. He spoke out about the company's inadequate response to residents' concerns, including things like drug taking in corridors, poor quality repairs, safety risks. It's very much in the public interest for Ben to be speaking out freely about these issues, because safety concerns in housing completely depend upon maintaining good standards, public accountability, and ultimately on this kind of whistleblowing. It's also the case that residents in the blocks had tried to raise the issues through official channels but hadn't been adequately listened to. So taking things to a higher level is quite legitimate in this case. Now, no one is saying that Ben didn't send a lot of communications and didn't publish information negatively about his housing provider, but this should be something that people are free to do, and Ben's activities have been vindicated in their substance. The evidence of the issues in his blog are very well documented. There's images and video footage that were published by ITV, who reported the issue based on Ben's public campaigning. There were also many, many complaints by other residents posted to Facebook. These have since been taken down. But there was an admission by the housing company in response to ITV that residents' complaints had not been adequately handled. Jenkins and numerous other residents have also now received payouts, and the Housing Ombudsman has found that the housing provider had failed to adequately respond to a series of serious complaints, including a rat infestation, a broken boiler, a burst toilet system, noise complaints, and a roof that needed to be repaired. But still, by speaking out about these issues which needed to be dealt with, Ben faced a series of legal threats for his campaigning. He was accused by GSA's lawyers of harassment, of copyright infringement for using their logo on his blog, and accused of putting himself forward to complain on behalf of tenants who should have contacted the company directly. It's a very familiar phrase that I've heard many, many times before. They claim his criticism was excessive. They said it targeted individual employees, which he named on social media, and they also said it was so frequent that it prevented the company from being able to respond to other residents' issues, which obviously they were clearly doing. GSA demanded in their legal threats that Jenkins signed undertakings to avoid legal action himself, including a commitment to refraining from any conduct that causes or is likely to cause a nuisance or annoyance to any of the claimant's employees, agents or contractors, a condition so very broad that Ben Jenkins felt he had no choice but to refuse. The letter itself threatened that failure to sign these undertakings could incur legal costs which are likely to run into thousands of pounds. This kind of threat made to somebody who lives in affordable housing is clearly a threat. Ultimately, Ben Jenkins did sign a more limited series of undertakings, but refused to take down his website criticising the housing provider. Finally, I want to say that the battle with GSA has had a serious and ongoing effect on Ben's mental health. He hopes that by shedding a light on these matters, the well-being and safety of residents will be protected, along with the proper upkeep of homes across the UK, and he wants to contribute to raising awareness about the challenges faced and assure accountability. I hope that the Minister today will look at this case, these issues of abuses of legal proceedings, the use of bullying lawfare, using money and resources to shield the powerful from proper public scrutiny when they should be held to account, and that the Minister will look at bringing in new action to put in a robust, broad and comprehensive bill to prevent this going on.